Okay, it's about 10:30, so we're going to go ahead and get started. Today, we're here to talk about we're going to talk about copyright, and particularly we're going to focus on images and photographs that libraries use for things like promotion. First, I'm going to introduce myself. My name is I am the library law consultant here at the Library of Michigan. And a lot of you know me. I have a law degree and a MLS. And I am here, excuse me, for just a minute. I'm making sure my slides go forward. And I am going to, let's see if I can get my slides to go. Sorry, we're having a little bit of a right, I'm just going to do it the hard way here just so that we can get going. Okay, this is my disclaimer. And my disclaimer is, well, now it's, oh, now it seems to be working. Sorry. Having a technical issue here. I'm going to ask everybody's patience here for 1 second while I take care of this problem. So I apologize, this should only take a minute. We had some computer issues yesterday and everybody's computers are kind of acting a little bit weird this morning. So I am not sure what's going on. I'm going to mute myself and I will be right back with you in a second. I apologize for the problem. My computer doesn't seem to want to properly advance. And I'm going to try one more time here. Oh, now it's working. Okay, let's just keep going. Okay, so this is my disclaimer. My job at the Library of Michigan is to provide legal information and to provide some context and assistance to libraries so they can understand when they have a legal issue or a legal question, so that they can understand what they're dealing with. My job is not to provide legal advice. If you need legal advice or you're involved in some problem, you need to contact your attorney. So if you get a letter from a license holder telling you that you're in violation, you need to contact your attorney. Okay. So let's start off briefly talking a little bit about copyright. So the images on here, all of which are either public domain or government images, are kind of like a little walk through the history of US copyright. So the first copyright statute came out in 1710 in the UK, and that was the first concept of this idea that anybody who comes up with a creative work deserves to have that work protected and not copied and not taken. After that, it was incorporated within our Constitution, so you can see that was about 70 years later. The founders incorporated that idea within the Constitution. And the idea is that by protecting copyright, by protecting someone's work, you are promoting the creative arts. So in other words, if you protect an artist's work, then artists are going to be more likely to create work. Because actually, as we're seeing right now, if you have an environment where material or people's works can just be taken and they can't earn money off of it, then a lot of artists are going to not create for the public. So the idea is that to protect the creative arts, and the same goes with patent, to protect innovation and to encourage that, because that is what partially creates a whole well-rounded society. The government is going to protect the works that are created and allow the artists to benefit from those works and be the primary benefactor of those works. Then in 1789 is when, if you see 1787 was the Constitution, 1789 is the first time a set of statutes came out. That's when the first Congress was essentially convened, and that's when they brought out laws. So the Copyright Act, its purpose was to kind of put into place the rules and the procedures that would allow the law to comport with the Constitution. That would actually be the functioning ability for people to retain ownership over their own copyright. Now, as this picture suggests, copyright law is not very clear. It's really kind of tangled. It sounds clear, but when you really get down to it, it's actually kind of cloudy and complicated. Then there were in 1886, if you move on to the next symbol, there was the Berne Convention, which was an international convention. Now, I'm not going to get into a lot of detail on this, but European copyright is a little different from US copyright, even just from the basis of what it believes. But overall, the one thing that the countries agree on is that an artist's ownership in their works deserves to be protected. The main difference has to do with length of copyright. And so in 1886, several countries got together and agreed on this Berne Convention, which would enable copyrights to be protected globally. So that even though if your copyright before that, if your copyright was protected in the US, it might not necessarily be protected in Great Britain. In 1988, the US finally joined it. The reason why the US didn't join it before then was because of one of these differences between the US and the international copyright. And before 1988, the US required that every piece of work that was copyrighted had to have the copyright symbol on it. It was called the formality. So people who created works had to go through the formalities of making sure that certain symbols and certain writings were actually imprinted on their works. Because if they didn't, then the assumption would be that it was public domain, that it was not under copyright. So if you created something, if you wrote a book or a book of poems, or you drew a picture, if you did not put that little copyright symbol with a date and the name of the person who had the copyright or the author, then the government could say, well, you didn't copyright it, so anybody can use it and anybody can take from it. Where in Europe, it was believed that just by creating it, the person who created it automatically had copyright. So that was kind of a big bone of contention for several years between the US and Europe. So in 1988, US finally came around and joined the Berne Convention. And so now in the US, it does not have to have a symbol on it in order to be copywritten. However, if something was created prior to the 1988 joining in the Berne Act, if it did not comport with the formalities, then it is possible that it might not be properly protected by copyright. That's kind of another story we're not going to get into right now. And then in 1998, the next big copyright thing was the Copyright Term Extension Act, which you may know, some people called it the Mickey Mouse Law, some people called it the Sonny Bono Term Extension Act. And what it did was it lengthened the amount of time that a copyright holder could have for their total protection of copyright. So they have their initial protection and then they can renew it for some years more. And in total, that turns out to be life plus 70 years. So that's just kind of a basic background of what we're talking about. So let's talk briefly about what copyright does in general. So we talked about, copyright protects the rights of authors who create works. It permits them to perform, distribute, and profit from their works. In fact, it gives them a monopoly over those works for that period of time that they own that work. It covers only works of authorship fixed in any tangible medium of expression. Now, you can see that the law actually anticipated improvements in technology. So it says now known or later developed. So in other words, if you just kind of have an idea, you can't copyright an idea or a concept. You can only copyright something after it's been produced, after it's been written, after it's been painted, after it's been photographed. And then again, authorship includes a wide range of creative endeavors, including, as you might know, pictorial, graphic, sculptural. Now, art, so painted fine art, if you're Warhol or you're Roscoe, or you're one of an artist, or you're anyone who paints, then fine arts are actually covered under a different section of the Copyright Act. But if you're an illustrator or you are snapping photographs, it would be covered under this section of the copyright that we're talking about, which is 106, 17 U.S. 106. So Title 17 of the United States Code is the Copyright Act. So when we look at photos and graphics, nowadays, most of us look at the internet, right? And, all photos and graphics now, after the Berne Convention, any photo and graphic is protected by copyright right now. So photographs and graphics, actually the copyright belongs to the person who created them. Now, there are some instances where the rights might lie with, say, a corporation, or whoever produces the item that the photo is on. But most of the time, the image, the photo, if you take a picture off the internet, the person who owns that is the person who took it or the person who drew it. So if you have a children's book and you look at the illustrations are owned by the artist. Even some quite famous ones, like the Harry Potter illustrations, are actually owned by they don't own the rights to the character, but they own the rights to those illustrations. So photos and graphics are protected. Never assume that something is not protected. So whether it's on Facebook, whether it's on Instagram, whether it's on Tumblr, social media, or any website, always assume that the graphics are protected by copyright. Now, you may think to yourself, well, if I'm on Tumblr, or I'm on Instagram, or I'm on Facebook, and I see a picture, well, that person put that picture there. So if I'm looking at an Instagram of an artist's own work, that person put that picture out in the public. So it must be okay for me to use. Well, it's not. You may think that, you go to a museum, which very often is, several of them are open to the public, like the Smithsonian. You can just walk in and you can snap a picture of artwork on the wall, but that doesn't mean you own that artwork. That doesn't mean now you have the rights to that artwork. You have the rights to your photograph. If your photograph, treats that artwork in an innovative way, or it has particular lighting, or it's a particular compelling portrait of that photograph, you own that photograph and the rights to that photograph, but you do not own the item that you're taking a picture of. So it's very important to note that, you can't just use something just because you see it on the internet. Now, again, even if you do Control Alt print screen, and you say, well, I'm just taking a picture of this picture, so I'm okay. Unfortunately, it doesn't quite work that way. In order for something to be protected, it has to have some kind of creative aspect to it. So just taking a Control Alt Delete is not really going to mean that you now have an individual work under copyright. The other problem to understand, and why this is becoming such a big deal right now, because libraries for years have been, for decades have been doing this, and it's never been that big of a deal, and you see, copyrighted characters on the walls of libraries, and no one's ever really paid a whole lot of attention. There may have been some kind of, once in a while you hear something, but overall, it's not really been getting the attention that it's getting now. And partly that's because more than ever, after the onset of social media and the internet, it's become so easy to steal designs and steal, artwork, that artists and photographers are really having a problem. Nowadays, the only way to get noticed in the industry is to have an Instagram or social media presence. My daughter is going to college to be an illustrator, and it's the only way to really get jobs is to create this portfolio on social media, because that's what the studios and that's what the representatives of publishers and stuff look at. But, if you put your artwork there, people take it. And, people take artwork and they take it to Redbubble, or they take it to Cafe Press, and they create t-shirts, but they don't even own the graphic they're doing it with. So a lot of these, illustrators and graphic designers and photographers are having it's a real economic issue. And particularly photographers, there's actually fewer people becoming photographers because it's just such a hassle. And some people on Instagram, there's actually been, both my husband and my daughter are artists, and they follow a lot of people, in social media and email and stuff. And a lot of artists are talking about problem is so bad that even some artists can't afford to hire the people they need to get the protection. So it's really a rampant problem. So you really have to look at it like every picture that you're using without permission, you're actually taking money from somebody. And yeah, sometimes that might be a big corporation and maybe, you don't care, but sometimes that could be just a person, who's just starting out and trying to earn a living. And that is kind of a problem. So let's address some copyright myths. So, a lot of people think, and again, this has been happening for decades. I've been guilty of this. I think most of the people on this webinar have probably been guilty of this, that, you find a compelling picture, or you're doing, your Star Wars or your Harry Potter event, and you just take those images, and you think, you know what, it's okay because it's educational use. I'm in a library, we're educational. It's okay because we're a government entity. We're obviously not using it for any kind of bad commercial use. It's okay because we're not making money on it. It's okay because we're a nonprofit. You know what? We're helping kids to read. This is for literacy. Everybody agrees that's a good thing. So it's not going to be a problem. Nobody's going to care. We're too little. Nobody's really going to even notice us because we're such a small little library. Nobody's going to care. It's okay because it's a viral photo. Everybody is taking copies of it and putting it everywhere. So it's okay. It's okay because I found it on a free government site. And isn't everything on a government site free? So these are all actually not true. And we're going to kind of walk through some of those. So the biggest myth with using photographs that libraries have is that it is educational. So the biggest myth is this educational fair use myth, that because a library is an educational entity, that we can use it for free. And that's really not necessarily the case. So while Section 106 does indicate, and there are some additional sections of the Copyright Act that does say that there are certain approved uses and exemptions from copyright for educational use, most of these exemptions have to do with face-to-face teaching in a classroom or online distance educational teaching. So it doesn't, something like what we're doing right now. Okay, so I have one or two images here that are kind of in a gray area as far as fair use. But because this is a webinar, it's an educational class, I probably can get away with it. But whenever you see educational institution in the Copyright Act, which is where most of these exemptions come from, it's talking about government sponsored or government run accredited institutions. Like, it uses that word accredited, which means it is specifically talking about K through 12 and secondary and colleges and universities. It is not talking about libraries. So if you're a library, if you're a school library, well then you're pretty much okay. If you are a regular public library, you can't hide under that educational. There's really no such thing as educational fair use, because even the educational exemptions have limits. Okay, so the educational exemptions, like I said, are mainly surrounded about classroom use. But even that has limits. A professor can show a movie in class, or a professor can, photocopy an article in class. But if that professor posts that article on, say, a Blackboard or some other content management software, they only can do that for one semester under the exemption. They can't continue to do it. So if they have the same curriculum every semester, after the first semester, they have to get permission. So even schools have to get permission to use copyrighted materials. So, you have to be very careful when you think, oh, I can use this because it's educational, because most of the time it's not. So a lot of times when we talk about fair use, and we're going to go through that in a minute, courts do tend to give a lot of weight to non-commercial use. Okay, so the reality is that if, as public libraries, as government, as commercial, and as places that do have an educational component, any court would look favorably on those facts, and those do tend to weigh pretty heavily. But other things that they look at are you from a very big library or a small library? Are you from a big university library that obviously has the funds that they could have paid for permission? Are you a very small library that maybe couldn't? They also look at what are you using and how much of it are you using? So there's multiple factors that go into this. And even though non-commercial use and a component of education does weigh heavy, it's not the whole story. So you have to be careful about that. So let's say you have something, you find a picture that you want to use. What are your options? Well, your first option is to look at or look for public domain, uncopyrighted, or orphan works. Now I'm going to get back to orphan works in a minute because that's also a little tricky. So public domain and uncopyrighted works, your best bet is simply using public domain works. That's going to be the easiest, clearest option. Uncopyrighted works are a little bit more complicated because trying to make sure they're uncopyrighted can be a little cumbersome. If you have a work that you're not sure about, okay, that you have something that you just can't figure out whether it's been copyrighted, okay, the standard of the law is to use a reasonable effort to locate. So what that pretty much means is you want to have a documented trail that you tried to find. So whether you're running searches at the copyright office, or whether you call the copyright office, or whether you talk to your attorney, or whatever you do to try to locate those, whether or not it's copyright and who owns it, hold on to that because you might have to prove that you did conduct a reasonable effort to see whether or not it was copyrighted. If it's from pre-1988 and there's no formalities on it, there's no copyright symbol on it, then it's possible that it's uncopyrighted and it's uncopyrightable, like it's not covered. Public domain right now is anything that was created pre-1924. Now, because of the Copyright Term Extension Act, a lot of things as of 2019, things as of 1924 are now available. But for example, Mickey Mouse doesn't go into public domain until 2024. So you have to kind of do that calculation. And I actually have at the end of this presentation, there's a lot of links for information and assistance. And one of them is a very good chart on terms of copyright that you can use to calculate whether the item you're holding is still in copyright term or whether it's in public domain. Your other option is to, and along with public domain and uncopyrighted, there's things like Creative Commons. There's several really good websites that has graphics and pictures that the people who created it specifically elected not to enforce their copyright or not to take advantage of their copyright. And I have a list of those also within this presentation. And you can just search those sites and then you don't have to worry. Some of those do require attribution, which means you have to have a little line under the photograph that credits the person, but you can use it no problem. And there is a wide variety of sites and a wide variety of options. So that, that and public domain are probably your best bet. There are some sites that also you can search public domain. There's also a site that has just government images on it, and I have links to all of those in this presentation. Your other option is to get permission. So if you have something that you just feel is very important, you're doing a Harry Potter day and you want to make sure you can use some Harry Potter images and, from that world. Well, maybe you have a teen group that wants to do a skit that deals with Harry Potter. And there's some issues there too, as far as like parody, but we're not going to go into those right now. So let's just, assume that you really have something you want to get permission for. You can get permission. Most license holders and copyright owners and authors and publishers have fairly well publicized contact pages for obtaining licensing and permission. I used to do this all the time when I worked in academia because I worked with professors that wrote, chapters of books and stuff, and they had to get permission for things like musical lyrics and quotes and all kinds of things. And it's really easier than you might think to get permission. It just takes some legwork. So for example, I included the website here for DisneyStudioLicensing.com, and in the upper right-hand corner, I have a copy of their form, and it's just a form that you fill out. You want to make sure you allow plenty of time because it can take a little while. You want to make sure that within it, you tell them that this is a public library. We're a small public library. We serve this many people. It's for a teen, ready to read, or a teen reading group. Make sure that you tell them, everything that you can to show them, look, we're not going to be making money off this. We're not going to be using your characters in an inappropriate way. I would suggest you send examples of how you're going to use those characters, because that's another part of the protection of copyright and licensing, is that some of the major reasons why Disney and Warner Brothers, and they go so hard after people who are, smaller entities that are using, like public libraries, they're using their illustrations, is because they want to make sure that the illustrations don't get used in a way that might harm their trademark or harm their the image of their character. The other option is you can go through the fair use steps. So let's talk a minute about fair use. So fair use first appeared in the current Copyright Act, okay, which is the 1976 Copyright Act, which has gotten amended multiple times. Before that, there really wasn't this concept of fair use. It came into being because what Congress did was they took several case opinions that, where people had been sued for infringement, and the courts determined, this is an infringement. And they came up with this idea of fair use, using these tests and these elements that came out through court cases. So it's kind of a codification of what was the common law, and the common law is pretty much what opinions in courts. So, the purpose of fair use is to allow people to do things like criticize or parody copyrighted work. It's also, to kind of encourage the use of creative works. But it's kind of a very strict balancing act, right? Because if you let people get away with too much, then it could affect the inspiration of people to create creative works. And that's really what copyright was designed to do. So fair use is very squishy, to use a technical term. It really is, sometimes it's very obvious, and sometimes it's very murky and hard to figure out. The problem is you don't really know you're right in how you figured it out until after you've done it and you either get sued or you don't. So it's, like I said, it's one of these leap of faiths. If you really believe that, and you feel you have a strong argument for fair use, then I would document it. I would go through the steps I'm going to talk to you about right now. Make sure you document why you think this is fair use, and hold on to that in case you get pinged. And the more that you're going to put the use that you are, the more that the graphics you use, okay, so any graphic that you want to borrow or you want to use, the more that you take that graphic and you put it out in the public, on your website, on your social media, the more you do that, the higher the possibility is that you're going to get caught. So you want to make absolutely sure that you have all your ducks in a row and that you have a very firm case for fair use before you do that. So one example of fair use, and actually one of the early ones here in the US, one of the ones that is used a lot as an example, is the Betamax case, which was the case that actually made it possible for us to use video cassette recorders, DVRs, and the like, because the court said that this idea of time shifting of television shows, of recording a television show for personal use later, was fair use. And obviously that was something that the production companies and the television networks did not like at all. But the court said, nope, if you're just time shifting, you're not doing it because you want to have a, display it to the public. You're just doing it for your own personal use, then that's fair use. You're not cheating anybody for that. So here is the 4-part test or framework that the Congress put in place to determine fair use. And this applies whether you're copying a chapter of a book or whether you're borrowing a photograph or a design, an illustration. So, or incidentally, if you are considering reading Story Hour on the internet through YouTube or something, this would also apply. So 17 U.S. Code U-107, which is the fair use statute, the four steps is: first, it looks at the purpose and character of the use, including whether the use is of a commercial nature or for nonprofit educational purposes. It looks at the nature of the copyrighted work. In other words, whether it's a fiction or a nonfiction, whether it's fact, or whether it's a truly creative work. It looks at how much you use in relation to the work itself. So if you're copying one chapter out of a 50-chapter book, you have a stronger case for fair use than if you are copying one chapter out of a 3-chapter book. It's going to look at the effect of the use upon the potential market. For example, I think a very good rule of thumb is that if you're using this as taking money out of the pocket of the copyright holder, then you want to give yourself pause. So if you're putting it on a t-shirt, if you're selling anything with it on it, if you are at all fiscally benefiting from the use of this character or of this design, then you want to really think very carefully about it. And that's one of the reasons why, for example, professors who were writing books were very careful to get permission, because they're making money, they're earning money on this book. The statute specifically states that if it's for criticism, comment, news reporting, or teaching, scholarship, or research, that's not infringing. But again, you have to be very careful of the use of those words and what they mean. Okay, so teaching has a very specific meaning to this statute, right? It's face-to-face, or it's, digital ed. So even though you could say, well, a program is teaching, you have to be careful. It might be and it might not be. Scholarship or research. So if you're writing an article that you're not obviously going to make money on, or if you're conducting research. So if you're making a photocopy of an article for, to research something, to write an article, then that's considered fair use. Okay, so let's walk through each one of these, and we're not going to go through the whole slide. I highlighted points that are kind of important. So first of all, we're going to talk about purpose and character of use, including if commercial nature or for nonprofit educational purposes. So these are actual quotes from cases and from the Copyright Office to give you an idea of how actually this works in real life. So the Copyright Office discusses fair use, and it says that the courts balance the purpose and character of the use against other factors. So purpose and character of the use is it looks at all 4 of these factors, and it balances some a little more heavily than others. Okay, so purpose and character is fairly heavily looked at, because this is, part of that commercial nature idea or the nonprofit educational idea. This step also looks at what they call transformative uses. For example, okay, what it means by transformative is, let's say that you want to use a particular illustration of Harry Potter. If you take that illustration and you're just going to blow it up into a poster and you're not going to change it in any way or include it as part of anything else, then that's not very transformative. If you're going to take it and you're going to incorporate it into maybe a collage that's in a brochure for your program, or you're going to incorporate it into, maybe you're going to do like a standee, and you're going to, have kids take pictures, and, there could be multiple creative uses that you're going to make of this particular illustration. So the more creative that, and the farther away it is from its basic beginnings, then the courts look at that more favorably, because you're not just taking it just to reproduce it. You're actually using it as part of something else. So the second quote there is something that I think is pretty important. A challenge to a non-commercial use of copyright requires proof that either the particular use is harmful or that it should become widespread, it will adversely affect the potential market for the copyrighted work. So what this is saying, that someone who, the courts strongly favor non-commercial use for fair use. And also in concert with other things of the 4 factors. But if you have a non-commercial use, that's a big strike in your favor. Not the only strike, but it's a big plus. So this is saying that anybody who wanted to contest that would have to prove that either you are using this image in a very harmful way, you don't want to take Mickey Mouse and use it in any kind of disgusting or sexually explicit way. You're not using it in any way that's going to mar the reputation of that character or how that character is seen by the public. And also, if that photo should become viral, if say you were to, start spreading it, then it's going to cause either economic or reputational harm to the entity that owns it. So that's one of the arguments against non-commercial use being fair. So those are some things to think about when you're doing your fair use analysis. If you say, look, I'm just going to put this on a bookmark, or I just want to make, I want to make wizard hats and I want to put, Harry on them, then, that is fairly transformative. That's somewhat transformative. And obviously it's not going to cause any, of those problems. It's not going to negatively affect the character. As long as you don't start selling them, you're probably not going to have it get widespread enough. It's going to cause a problem. So the whole page essentially is giving, gives some extra information for you to kind of evaluate whether this first element of fair use. So transformative use, non-commercial counts, does really help you. You want to look to see if anybody can refute that non-commercial use through the way you use it. You don't want to automatically assume because it's fair use, you don't have to walk through this analysis. You want to make sure that, you want to be careful that you don't profit from the use. So that last quote is, whether the user stands to profit from the exploitation. So, and profit, you want to make sure that, you're not making money off of this nonprofit use. So the second step is nature of the copyrighted work. So this really has to do with, is the use of this work going to deter creators from creating more work? Is it really going to kind of harm the whole idea of artistic expression and creativity? And is it going to kind of go against what copyright was created for? And what the courts look at here is the more creative or imaginative the work that you want to use is, the harder they're going to look at it. So for example, if you are borrowing a list or you are borrowing a newspaper article, then those are considered facts. So that is probably going to be less scrutinized as far as fair use goes than the use of Harry Potter or the copying of, say, a chapter out of a work of fiction. So it doesn't mean you're out. It doesn't mean you can't do it. It just means that this is another thing you have to consider. That if you're using a creative work, it might get scrutinized a little bit more. However, the courts also look at whether or not you're using it for a socially beneficial goal. So if you're using a creative work, you might think, well, that's a bad thing. But if it's for a socially beneficial goal, which I think we could all agree, and most courts would agree, literacy and public libraries are, for the most part, a socially beneficial goal. So courts weigh the socially beneficial goal analysis higher than the fact that it's a creative versus a factual piece. So again, if you're doing it for a socially beneficial goal, so if you're, it's part of summer reading program, or it's part of another initiative that's designed to get kids to read, and maybe not just a social practice. Like your program is not just strictly for social or just for fun. It has an element of literacy or some, overall socially beneficial goal, then again, that's another point in your favor. Then we have amount and substantiality of the portion in relation to the copyright work as a whole. So how much of the work are you using? Now, when you're dealing with pieces of, graphic work or a photograph, obviously, most of the time you're going to use the whole work. It's difficult to break up a photograph or a piece of art. So you could take an illustration from a Harry Potter book and you could say, well, I'm only going to use Harry. I'm not going to use any of the other characters in this particular illustration, and that's fine. So that would be less of the work. That's not the entire work. But if Harry is the central character in that particular photo or that particular piece of art, then the fact that you only took a portion might not matter, because it's not just how much you use, it's the quality of what you use. So in other words, if you take a chapter of a mystery novel, you may say, well, it's only one chapter out of 10, so it's not really that big a deal. But if you take the last chapter where all of the mystery is revealed, then arguably you're taking the most important chapter, and that could make all the difference. Because for a publisher, if the last chapter gets out, then that could cause a problem with the selling of that book, even if you had the most socially beneficial goal in mind. So, that's kind of a two-pronged thing. So you're looking at how much of the work and the quality of the work. Now, again, that doesn't mean you can't. Just not saying that you fail this particular prong doesn't necessarily mean you can't do it. Again, it's a mark in the con field as opposed to the pro field. Most of the time with photographs, you're just going to use the whole thing. So it's really a question of, and as far as quality goes, again, it's really just a photograph is a photograph. So, this particular prong is kind of, or this particular step is kind of difficult with photographs because you have to use the whole. So it's not, there's really not a whole lot you can do about that. It's the other steps that you really just have to kind of emphasize. Effective use upon a potential market. So here, it's really about whether or not your use is harming the market for this particular item. So again, if you are taking the last chapter of a mystery, or for when you hear that, in fact, just recently, one of the actors in the new Star Wars movie had their script stolen from their house. So if someone steals that script and then releases it on the internet, that arguably is not a fair use of that script, because it could affect the market for that film if everybody already knows what's going to happen. It's also, if you're just taking, again, an image of Harry Potter and you're incorporating it in your materials for your programming, again, as long as the use is in keeping with the use of that character and is in keeping with the image of that character that the owner has cultivated, then, and you're not making money off of it, then chances are it's not going to affect any kind of market. Now, and again, this can get very sticky. Okay, so if you're going to create t-shirts out of it, that could be a problem, because someone buying your Harry Potter t-shirt might not buy a Harry Potter t-shirt from a licensed person. So, you have to be, again, very careful about where you use this and how you use it. Okay, so let's talk about this in context of a real library problem, okay? And that might kind of drive it home a little bit. And it looks like we still have time. So let's say your library has a very enthusiastic teen or tween group, okay? So you're gonna have a Harry Potter palooza weekend at the library. You're going to have cosplay contests, trivia games, wand making, and all kinds of, book readings. And your teen librarian wants to create engaging flyers and social media. So would fair use permit her to do that? Copy some illustrations from Harry Potter. So let's take a moment and talk about copyright versus trademark. So quickly, we just talked about copyright. You know that covers, creative works like books and art. Trademark is designed to cover symbols and recognizable designs that identifies products and services from their particular source. In other words, trademarks are specifically aligned with business, with a corporation and a corporation's products. So, Harry Potter is trademarked as well as copyrighted. So you may have an illustration of Harry Potter that is copyrighted, but Harry Potter, the character, is trademarked. So, you may think, well, is it a trademark problem or is it a copyright problem? Well, if you're using an illustration, it's a copyright problem. Okay, the trademark issue really doesn't have like a fair use equivalent. With trademark, a lot of the issue over trademark infringement has to do with whether an item could be mistaken, whether an item that has used the trademark or is copying the trademark could be mistaken for the actual trademark. So example, the fake purses that you can buy on the streets of major cities, like, the Fendi purses or the Gucci purses or the Louis Vuitton purses, those are problematic trademark infringements because people buy them either thinking they're the real thing or in lieu of the real thing. And so that's a problem. If you were to take Mickey Mouse and put Mickey Mouse on, a cup and sell those cups, that could be a trademark problem, as well as possibly a copyright problem. But if you were to take, Harry Potter or Mickey Mouse and put it on a library brochure and specifically state that this is a library program sponsored by the library and you properly attribute it, then it's unlikely that you're going to be in trademark infringement, because it's unlikely that the average person is going to mistake a library program for something that's been put on by Disney or by Warner Brothers. So, but again, in some instances, you might have to be very careful. And again, a lot of those instances has to do with items, putting things on cups or putting things on buttons or putting things on t-shirts, okay? And that's where I would definitely talk to your attorney. You want to know the item that you want to use. In almost every instance, the artist or the photographer is the one that owns the image, okay? There could be some tricky things with corporate images like licensed images, right? Which we just talked about, the idea of a trademark versus a copyright. Permission to use the photo or the illustration should come from that owner. So either the artist or the photographer. You want to be careful about getting stuff off the internet, because sometimes stuff off the internet, particularly Twitter and Facebook and Instagram, is because the things that you see, the illustrations might not in themselves be, they might be like fan art, which means if you see a piece of, fan art, that's again, someone who just drew a picture of Mickey Mouse, but they're just like you or I, or they're an upcoming artist, but they don't own the rights to draw Mickey Mouse, they're just doing it. If you wanted to use that picture, you would want to get permission from that artist, but again, be aware of the trademark infringement, issue. For permissions, you start with the source of the photo. So if you see a photo on Instagram, look at who posted it, okay? You want to, look at the photo very carefully and see if there's any attribution. You want to, if you can't find any attribution and you can't find anything and it's not on a government site and it's not on one of these sites that, like Creative Commons, I would not use it if you can't figure it out. If it has some kind of notation on the bottom that states who took the picture, or there's some kind of context, it's part of an article or something, then contact that photographer. And usually a search of the internet would reveal the photographer, or a search of social media. Even photographs in newspapers and magazines are copyrighted. To get permission, Okay, let's say again, we're looking at Harry Potter. With something like Harry Potter or Star Wars or Mickey Mouse, unless you're dealing with, say, the illustrations that are in the books. So you're looking at a famous illustrator. So like say Star Wars, you're looking at Ralph McQuarrie, or for Harry Potter, there's a couple of artists who did the US version of the books and the British versions of the books. If you want to use those illustrations, or if you want to use, say, portions of pictures from the films, then you want to go to those sources. So portions of the films would be from Warner Brothers. If it has to do with the illustrations, those are from those artists. So the British illustrations are from Jim Kay. And you can even go straight to J.K. Rowling, who she still owns part of Harry Potter. She doesn't own everything still, but she still owns part of it. So you have a couple options here with Harry Potter. So where do you start? Well, like I said, a lot of it depends on exactly where your photo came from or where your art came from. If it's from the movies, you probably want to start with either J.K. Rowling or Warner Brothers. So you can just run a search. If you run a search of J.K. Rowling, you come up with her webpage. On her webpage, it states her management, her artistic management. You would go through the artistic management and just shoot an email and ask for permission. If they're not the ones who should give it, they'll refer you to the correct person to ask. You can contact the studio. Just like Disney, Warner Brothers has a whole organized page for obtaining licensing. And you just fill out the form and you explain who you are and what you want to use it for, and send a sample if you can, and you ask permission. Now, they may come back and ask you for money. They may not. You can, within your request, you can say, you know, we're a small public library, we don't have a lot of funds, and they may not. But, you know, and you can be persistent, but, you know, that's how you would do it. And it does work. It just sometimes takes a few back and forths. So you want to allow yourself plenty of time. For book illustrations, you would go to the artist. And again, if you type in the name of the artist for Harry Potter, again, the British artist is Jim Kay, you come up with his and his wife's website. And on that website, he mentions who his artistic representation is. And you go to their website, which is this Alison Eldred, and you go to her website, and she, again, has a very organized section that walks you through getting permission. So pretty much anybody who is a creative artist, or anybody who puts out materials that are of value that people might want to use, there are ways to get permission. And it's really not that difficult. It can take time, but it's not that difficult. And it may mean a charge. Now, when you talk about fine art, like paintings, like Andy Warhol, or photographs like Annie Leibovitz, that permission, there are some different things with the copyright rules and fair use. But you can, you know, also get permission from them, but that would go, also you would start with either Warhol's estate, you would start with Leibovitz's page, and then you probably end up with their representation as well. So let's kind of walk through the fair use of this particular problem. So as far as purpose and character of use, we have, well, our program and the use of this image could encourage interest in reading, right? Because if people like the Harry Potter movies, they might be interested in reading about Harry Potter. And if we make our program fun enough, and if we can make our programming materials engaging enough, we might attract teens and tweens that don't normally come to the library, and we might ignite their interest in reading and therefore improve their reading, which everybody agrees is a really noble goal. It helps. Using this would help the library put on a successful program and grow this program, and would help libraries encourage people to come. So both of those things are socially beneficial purposes. It is a nonprofit use. We're not going to benefit from this. We're not going to sell t-shirts. We're not going to charge admission. We're not in any way going to gain money from the use of this character. And the use would be as transformative as we can make it in terms of we're going to integrate this images into a custom design and theme for our program. And we're going to use it like in a collage with our marketing materials. The nature of the work. Well, it is a fiction work, but we are going to try to make it transformative. However, it is definitely a socially beneficial goal. So, you know, since it is socially beneficial, the courts probably would look less at the fact that it's a work of fiction. The amount and substantiality of the portion. Well, we're not using the whole franchise. You know, we're just using Harry Potter and maybe, you know, a picture of Hogwarts or, you know, but we are using an entire illustration. So if we, you know, remember, we're looking work by work. You can't say, okay, well, I got, you know, I'm going to use this Harry Potter illustration, so therefore I can use all of Harry Potter. Nope. Each individual illustration you want to use is going to have to go through a different fair use analysis or a different permissioning process. So I'm just going to use, you know, but I'm going to use the whole picture, right? So that kind of might count against us, but I'm going to incorporate it into another work, right? Which again could lessen that mark against us. The effect of the use upon the potential market for or value of the copyrighted work. Well, this actually could be good for the potential market because we're actually marketing Harry Potter. We're encouraging teens to look at Harry Potter. We're nurturing the love of Harry Potter and the fandom of Harry Potter. So our goal is to actually gain new fans for Harry Potter, which could actually improve the market for the copyrighted work. So that's actually a good thing. We want to inspire reading of the services. It's unlikely to inhibit or negatively affect the market. Again, unless you use an inappropriate depiction or you use the depiction in an inappropriate way, which we are not, that is not the plan here. I would probably limit recording and posting. I would probably not, in order to better secure my fair use argument, I would not put it on social media. If anything I put on social media would probably be a PDF of my brochure. It would make it more difficult for anyone to capture the image from the PDF. And I would use whatever technological means I had at my disposal to prevent people from being able to lift the image from my brochure. So I would be very careful in how I you know, presented it on social media if I was going to. So what's the result of our analysis? Well, it is very possibly and likely fair use, but, and I have to be really clear about this, fair use is a very squishy concept. And even if you are absolutely sure in your mind that it is fair use, it is still possible that someone could send you a cease and desist letter. The only time that you are absolutely safe is if you're using an image or a photo that is in public domain, is on one of those websites where there's no claim of copyright, is a government photo, or you have a permission, you have a license from the owner to use it. Everything else remains in a gray area, even if you really think that it's fair use, because nobody's going to give you a fair use stamp of approval. Ultimately, fair use is only decided after the fact if you don't get sued, right? And even then, the fact that you didn't get sued, you can't be sure that, you know, it's because you were right. It could just be that nobody noticed. So if you're unsure and if you're dealing with a very large project, okay, something that's going to get a lot of attention, a major, say, fundraising project, it's going to be worth it to confer with your attorney because it's not worth the embarrassment, it's not worth the cost. Right now, and I have an example of this in one of my slides. I'm going to backtrack here for a minute. Right here in the upper right-hand corner where it says find and fight image theft. So right now, one of the reasons why we wanted to hold this webinar, and I have like a minute left, is because, actually 2 minutes, is because what is happening is artists and photographers are hiring companies that essentially what they do is they crawl the internet and they look for unlicensed usage of photos and images. And even smaller artists are doing this. If they find one, they take a snapshot of it, and then they contact you and they tell you, we have proof that you use this photo without a license, and now you owe us a couple $1,000s or more, depending on the use and depending on how many times they found it on the site over a certain period of time. So it's thousands of dollars that libraries are being pinged. And once you get that letter, there's not a whole lot you can do about it unless you can absolutely prove fair use. You know, and it can get even more expensive to prove that fair use because you have to go now into litigation. And so, you know, that can cost thousands of dollars with your attorney. So in the end, it just isn't worth it. So, you know, think very long and hard about whether you want to take photos that you're not sure about and that you're not getting permission for, or licensed items. And if you're going to use those licensed items, do it very carefully and strategically and follow the rules. So what about taking your own pictures? Well, the main thing here, you would own those pictures, so you could take those. You want to be careful about taking pictures of people and then putting them on, integrating them into some kind of marketing thing. We all own our own likeness. And using someone's likeness without their permission to promote something can be problematic. So at programs, you all know, a lot of you already get permission. You don't want to take pictures of minors except from the back of their heads, especially if you're going to put them on social media, unless you have explicit permission from their parents to do that. Government employees, including library employees, are fair game for pictures if they're conducting their work. So if you're at the circ desk and someone comes in and takes a picture of you, that is okay, whether with your permission or not. However, there are entities coming in and conducting fair use First Amendment audits where they're just coming in and demanding to take pictures. Libraries, as a limited public forum, can limit where and how pictures are taken, but you can't prevent them from taking pictures altogether. So on here, I have some plenty of free image sites. So all of these are sites that don't cost anything to use and that have a lot of range of free, really good quality pictures. Here's some additional resources on the legal aspects, like on fair use and on copyright in general. Here is some more. And I thank you very much. We are about at 11:30, and I will be sending everybody copies of this presentation. The video or the webinar, the recording will be posted to the Library of Michigan's website as soon as it gets ADA compliance to put the content on the bottom. And that's it. I hope everybody has a good holiday. Thanks for attending. I hope everybody has a good day today at work, and take care. We'll talk to you soon. We'll talk to you next month. Thank you.
Shoot.